As a real estate agent, every single transaction we do, we can find out whether or not a customer has an estate plan. And of course, transaction, find out how well it's put together. So it becomes very, very important for us. And that's why I always try to meet new people as well as people who have a professional approach to estate planning. Really excited to have today past guest on another podcast, Robert Silverman, who's attorney Silverman and Jaffe that does comprehensive estate planning. Robert, thank you for joining us today.
Thank you for having me.
So let's talk about estate planning kind of in the global sense in that a lot of people have them, but sometimes they have them but haven't thought it through. So I'm sure in addition to doing estate plans, you have people come to you with problems in estate plan that wasn't really done properly or sufficiently. What are one or two of the most common problems you see in estate plans that aren't appropriate or personalized properly that you can help somebody fix?
Well, boy, the potential problems are numerous, but I think using poor or outdated forms or software is an issue, unfortunately, using a lot of the online kind of services or paralegal services without the help and advice and assistance and instructions of a very experienced estate planning attorney can produce a lot of gaps. So some parts of the documents or a lot of the documents could be could be done properly in a sense, but maybe that lacks some refinements. And a lot of times it's not necessarily the documents, but it's the funding, particularly of the living trust. The trust is maybe done okay, but sometimes the client comes to me and I said, okay, this living trust, I've got some suggestions, some recommendations, but let's talk about the assets and what assets are titled in the trust. We call that funding the trust. And they look at me sort of like with a blank stare and say, oh, I don't know anything about that. And my assets are just in my name or my spouse in my name. And we didn't put anything into the trust. I said, well, that's an issue.
The classic case as a real estate agent is you talk to the client and they mention that they have a trust and you're all excited because you notice the property is not listed in the trust. And they bring out the fancy booklet. It's always, what's that material? It's kind of like a plastic, like a naga hide or a synthetic material. Beautiful notebook, thick with all kinds of papers. They pull it out. And on top, slipped on top is the grant deed that was prepared but never executed or recorded, which is the same as saying it's like they bought a safe and put the gold bar on top of the safe. They didn't put it in the safe and close the door and spin the lock. Is that a fair equivalent?
That's a good analogy. Absolutely. I think there are a lot of potential issues that arise in connection with funding. Real estate is a big one, particularly with values that we have here in California. Not only can probate be triggered because an asset was not in the trust, but that probate is potentially very expensive and inconvenient for the typical, California property. So, every attorney works differently, but the attorneys who handle things more comprehensively, we shall say, not only research the title, prepare the deed properly, have it executed properly, and do that in their own office with a notary in their office and so forth, but they also submit it for recording and make sure that they do that properly. There are, not huge numbers, but there are clients who come in and say, yes, there was a deed, like you say, it's either unexecuted or even if it's executed, the attorney told me to go get it recorded. I don't even know what that means. I don't know where to go, what to do, and so I've never done that. So it's just having lay people, no matter how smart they are or whatever experience they have in their own fields, they're typically not lawyers and they don't know what it takes to do that. So the scope of the services offered by an estate planning attorney in connection with assistance with funding, including doing the trust transfer deeds and getting them recorded, think is very critical.
Something that happens in LA County increasingly, it's rare, but increasing frequency. For a variety of reasons, the county recorder's office now kind of acts as a quality control check now, where it used to be they would record anything because you were just recording the document. Now they do take a look at the chain of title because there's been so much fraud. Whether they should or not my job, but I can tell you that we've had on regular real estate transactions, deeds kicked back for various reasons. Some number was done wrong, or there was a gap in the title that the county wanted some sort of explanation, or there needed to be a death cert original attached to the document. And so those are when we have professional escrow officers or attorneys doing the work, all the more so with a consumer who, for once in their life, is going to the county recorder's office, and for them to create the document and execute and then take it to the county, to me, it just seems like a losing proposition. So I think that you have colleagues who make the case, I'm the attorney, not the recorder. I'm the attorney, not the personal finance manager. Fair point. As a businessman, I can say I wouldn't refer a customer to such an attorney because I feel like our job is to satisfy the customer's needs. And if you're not getting it recorded and confirming it, like I do that when I refer a customer to an attorney, I want to make sure it's recorded because my reputation's on the line. Why would the attorney not do that? So I apply that that's what you do. I know we talked about this previously. I wouldn't be interviewing unless I knew that's what you did. But I will say I've had attorneys argue with me. I'm open to the argument. And certainly legally, I see why you may not want to take on the liability. But I feel like our job is to make happy customers. Sometimes you have to take a risk and do your job and make your customer happy.
I think that's a valid point. In real estate is particularly important, again, because what's at stake, it's oftentimes the client's largest asset by far, often. And but the other side of funding, or the other piece of funding a living trust is personal property. That is, not only tangible property, that's different. There's no titling method for your watch or your painting, but for bank accounts and investment accounts, for example, it's important that those get changed. We don't actually do that, and most attorneys don't actually go down to, Wells Fargo or Schwab or Fidelity to change the title from the client's name to the living trust. We give them the tools. We give them a set of written instructions. We coach them. We're available for support. But we tell them how it's very important to do that. Yeah. So when you asked earlier about sort of gaps that happen, one of the gaps when people come in and they do a review, and I always cover not only the documents in detail, but this whole idea of funding the trust, they don't realize that substantially all of one's assets have to be titled in the trust in order to avoid probate on your death. So if you, for example, you have a home and you have that in your trust, and you have some bank and investment accounts, and most of them are in the trust, but gee, your Aunt Millie left you, $250,000 or $500,000, and it's just in an account with your name on it. Maybe you put it in your name only, and you're married because you wanted to distinguish it as your property. So it's just in your name and not in your living trust. Well, there's a limit. The legislature basically says that if you die and you have substantially all your assets in the trust and less than an aggregate of today's figures, $208,850 worth of assets like bank accounts and investment accounts and automobiles that are not in your trust, then you're fine. There's summary procedures. But if you have more than an aggregate of that threshold, $208,850 of assets, then those assets above that, all of those assets that are not titled in your trust need to go through probate. And one of the big advantages of a living trust is probate avoidance. And so people don't realize all it takes is one account or an automobile and an account to get over that threshold. And even if all your other assets are titled in the trust, you're going to trigger the very probate, even though it's going to be smaller, but you're going to trigger that very probate that you were trying to avoid in the first place by doing a trust.
Yeah. So, and it's funny, I had this conversation with an attorney about a year ago, and I was talking about bank accounts not being titled in the trust. And I used to keep my trust documents in the original. I have a scanned copy, but the original I used to keep in that file cabinet right behind me. And I remember pointing to it thinking, oh my gosh, we just changed investment companies. So my son-in-law went to work for a different company, so we moved our accounts there. I said, I think we forgot to put it in the trust. I'm in the middle of a podcast realizing I'm like the shoemaker whose shoes aren't, whatever, the kids' shoes, no shoes. That was me. So for all of us, I think it's always good to take a look at this stuff every couple of years and make sure you're up to date. So I will say, fortunately, I did get it titled, and I was kind of embarrassed, but I tell that story just to say we ought to be on top of that. I literally had a phone call yesterday from a colleague, a real estate agent, who had a little different take where the decedent had a trust. The decedent mentioned his residence as being in the trust, but didn't put the property address in like an Exhibit A. And so many times I see what trusts are done, and the attorney will prepare a separate exhibit that has certain property they want to put into the trust. Maybe if it's one property or several properties. And in this case, and I'm not sure who did the document, I'm guessing it was one of those online services where they told you to fill out the Exhibit A and they never did. And so they have this trust, and it says the property owner, he actually owned two properties, a residence worth about $1 million or more in San Francisco, and then a kind of a vacant lot worth maybe $150,000, $200,000 separately. Again, might trigger a probate depending on what it's valued at. That's a whole nother discussion. But this was a trust that somebody did that clearly, in of itself, didn't. I mean, I guess I think the answer is going to be if there's objectors. In this case, there are, because there's some heirs, and then there's the beneficiary of the trust are different. Seems to me that the heir is going to say, "Hey, that trust is no good, and it should go through probate, and we're entitled to it." And he's going to say, "Well, the trust is good," but the title company is going to see that it doesn't have the property on it. And so it's one of those things where yes, you can fix it in court, but it's about the same as a probate, right? I mean, there's a term, a Hegstead petition, where you can file to move something into the trust. Well, you have to go through probate, you just do a Hegstead petition. Yeah, but that costs about the same, it takes longer. So these things, I guess that's a long story to say, it's important these things be done properly to avoid litigation or narrow the points of potential conflict in litigation.
Yes, and Hegstead petitions, which is they're a petition to, if there's enough evidence of intent that the decedent intended the asset to be in the trust, then it is generally quite a bit shorter and quite a bit less in fees to petition the court to with a Hegstead petition, which is again, in short, just asking the court to deem that an asset that is not in the trust is to be in the trust based on the intent, as opposed to even though it hasn't been properly documented to be in the trust, not titled properly. But like you say, it is a probate proceeding. The court is involved. There are some significant costs, fees and costs. And so, and they can be avoided pretty easily on the front end, so that the family doesn't even have to do the shortcut probate proceeding, Hegstead. They can just sail along and administer the trust privately and more efficiently.
And I think, not to be argumentative, but just to point out other potential cases. While in general, an unopposed Hegstead petition can be simpler, easier, faster. Like in this case, quite often they're doing it because there is some opposition, which by definition takes longer and costs more money. And at least in LA County, I want to say attorneys will charge maybe $10,000 to do a Hegstead, which is maybe $500,000 probate, for a lot less work, but it's still $10,000 plus fees. And I also will say in LA County, to get from filing to probate hearing for letters of authority might be 35 days on average now. A Hegstead is going to be 6 months. I don't know why. I can tell you, I can look at the filing and tell you it's 6 months. You file and you're not going to get a hearing for that time period. So it's faster in a sense, but it may not be. And then of course, if it's contested, now you're just in litigation. That could take the rest of your life, right?
Yes, and I think it's important to say that we're talking about California law, and as opposed to many other different kinds of procedures might be available, and they might call it something different in another state. But and also there's a lot of differences within counties. So I'm up in the San Francisco, my office is in the San Francisco Bay Area. I handle matters, estate planning, probate, trust administration throughout the state. But there's quite a bit of difference in terms of timing when you can get a hearing between counties.
No doubt. And I literally track every hearing in LA County, track those statistics monthly because that's my business. And I can just tell you what, I know LA, it's 6 months to get any 850 petition hearing. I don't know why. I mean, maybe there's a reason why. It makes sense, but I can just tell you, it's unless you do some sort of ex parte or expedited matter, it's a 6 month process. So it's easier unless it's not. It's faster unless it isn't. So it's one of those things where you go to court, you never really know. It's kind of like Cracker Jack. You remember the old days? You used to get like a prize in the Cracker Jack. You never know if you get like a little booklet or a ring. You just never really know what you get when you go to court. So. Very
true. Very true. Hey, I wanted to just piggyback on what you were talking about, kind of updating. You mentioned, good idea to every few years, kind of review and so forth. That is, it's not a super common misconception, but it is out there a bit that, it's a one and done. I'm going to go do an estate plan, living trust, power of attorney, healthcare directive, will. I'm going to get everything taken care of, and I can check it off my list, and I'm done. I did the adult thing. I helped my family, and I'm done. No, you're not, or you shouldn't be. And so different attorneys have different benchmarks. Our benchmark is every 3 to 5 years. You should go in, talk to your estate planning attorney, get it reviewed and updated, or sooner if any material, financial, or personal matters have changed in any way. So that alone, regular reviews and updates can identify and then be a means to solving a lot of problems that may exist with an existing plan.
Well, and again, being on you also do trust and probate litigation. So being on the other side of we didn't plan properly, right? Almost by definition, litigation is somebody didn't plan ahead, so now you're fixing it by going to court. Relationships change, right? You have a good relationship with a spouse or a sibling, and 3 or 5 years later, it can look completely different. And so the person you had as the executor of your will, or to be the successor trustee of your trust, could be a completely different person 3 or 5 years, whether for the good, or they move out of the country, or they're married, or they're, who knows, health-wise, all these things change. And so I know for us, again, same thing. When I remember I looked at my trust, I said, well, hold on. We wrote that when my daughter was like, a teenager. Now she's married. She has a great husband who can assist her. And, there's a better answer to what we had before with my sibling, my brother who I trust, lives in Israel. Well, he's not going to be such an effective successor trustee, probably. I mean, he's a competent guy, but so these things change. I guess all that's a way of saying get in touch with your attorney every 3 to 5 years, and certainly when things change and laws change and preferences change, health directives. That's been a whole nother area of immense changes of who makes these decisions and who doesn't. Relationships change.
For sure.
So let's talk a bit about the non-financial part, health directives and who has access to making decisions. I think there are certain assumptions made, for example, that people feel like, well, we're like husband and wife, therefore we have the same rights. And that might be true in some courts, as far as spousal support or a division of assets or things like that. Commingling of money, can lead to different issues. But when you talk about health directives, pretty much a spouse is a spouse, and if you're not, you're not. Is that pretty much true? And that's why those things need to be accurate and updated?
Well, yes. Regardless of the relationship, the healthcare provider in California listens to and takes sort of direction from the patient. Of course, that's fundamental. And so a patient can, regardless if they have a healthcare directive that's executed and in place or not, they can revoke that anytime. So they're the boss, they can make the decision. But it's when they are not incapacitated, or another way of putting it is they are incapable of articulating their wishes to a healthcare provider, either temporarily or permanently based on some medical condition. The healthcare provider, the healthcare provider is bound by HIPAA and CMIA, which is the California equivalent of the federal privacy laws. These are serious laws, and so they can't, for example, give medical records and discuss these things unless they're talking to an agent under the healthcare directive. It doesn't matter what the relationship is. So it's really important to execute an appropriate healthcare directive, which should have either a standalone or an embedded in the document HIPAA release, so that the healthcare providers know that they're released from liability and they are authorized under the privacy laws to disclose information and medical records. It's critical, let alone use the healthcare directive to provide guidance to your loved one who you've chosen and trust to make medical decisions for you. Things like no heroic measures clause, whether there's authorization for organ donations, how, or if you care, you want your remains disposed of, cremation, burial, etc. There's a lot of guidance and direction that can be given by having the right terms in your healthcare directive. But of course, the fundamental thing is making sure that you have the person in that you want to be making healthcare decisions for you that's in place as listed as an agent in the document, and having alternates as well.
I do this podcast, yet of course my family doesn't watch my podcast. So I had a family member, unfortunately, who had a like spouse they lived with for, I want to say 40 years or so. She was divorced and never married this guy because she had spouse support up until she got remarried. Well, they made the decision never to get remarried. They lived like husband and wife, and in every regard we called him uncle and all that. Unfortunately, when she went to the hospital, there was some question as to whether she had certain insurance, and she didn't have access to the records because she was incapacitated medically, and he couldn't get the insurance company to give him information because he was, to them, nobody. And it's not, he could prove he lived with her for 40 years. They loved each other. There's all kinds of photos of the two of them hugging or whatever whatever proof you would have that he's like a spouse. He passed that test, but to the insurance company, for their protection, and I guess in this case for my aunt's protection, they weren't going to give him anything. And the stress that goes at that moment is just off the charts. And I can say afterwards, hey, you should have had an estate plan and gone through your health directives. You could have appointed, whether he's a husband or not, he's power of attorney or whatever you want to appoint. These are things that, you see these after the fact. I'm sure they come to you. The cows got out of the barn. How do we get them back in, as opposed to planning ahead of time? How do we get more people to plan ahead for these situations?
Well, that's the $1 million question, or the $10,000 or $100,000 question for sure. I've handled so many cases over the years. I've been practicing 32 years, so I've seen a lot of cases and handled a lot of things. And it's really shocking and sad to see what some of the unintended consequences are of the failure to plan. I mean, we've been talking about trusts and funding the trust and all that. We probably ought to take a step back, is at least have a will. Every state has has statutes that deal with what happens to your assets on your death if you don't have a will.
Right.
And that's called intestate succession is the legal term. And so we have these intestate succession statutes that dictate where it goes. And it doesn't matter if the decedent wanted it to go that way or not, right, or intended it to go that way. They don't have a will, and it's going to go based on those laws, which can produce awful results. I handled a case maybe between 5 and 10 years ago where, very sad, a wonderful married couple with no children were husband and wife were living together, and they had been married for 20 years. they were living in the wife's home that she bought before the marriage. She owned it individually. It was just her name, and they treated it as their property. They would have wanted, of course, on the death of either one of them, they wanted and expected that it would go to their surviving spouse. And tragically, the woman who was in her early 50s had a surgical procedure and got an infection and died in the hospital. Didn't have a will. Her husband came to me and said, what do I do now? And we don't have a lot, but we have this home. And, it's my wife's name is on it and all that. And I said, well, is it community property, separate property? Did she acquire it before the marriage or whatever? Yeah, she acquired it before the marriage, but we treated it as if it was, both of our property. So I had to bear the bad news is, hey, look, when you die intestate, even if you're married, if it's community property, then the surviving spouse has 50%, owns 50%, and gets the 50% of the deceased spouse. That's fine. That works out fine. If it's separate property, which this was, it was brought into the marriage and kept separate in terms of title, then the spouse gets a certain fractional interest, but not the whole thing. And depending on if there's kids or other relatives, the relatives, in this case, they didn't have kids. So the decedent, the wife, had two siblings. And each, the law said that the spouse had was entitled to 1/3, and each of the siblings of the deceased spouse were entitled to 1/3. So we have 1/3, 1/3, 1/3. The husband thought he was going to get all the house, and he was only getting 1/3. To make matters worse, the wife's brother, who's in a different state, and she were estranged, hated each other. She would have never wanted him to get a share, but he was entitled to a share of 1/3. And so, fortunately, I was able to work it out, and he ended up getting, after some negotiation, and there's a lot of drama there and a lot of facts that I don't want to go into, but it ended up working out. But it's very unlikely that most cases are going to work out like that, where the husband gets, the surviving spouse gets all or most of it, when the law said the other happens. And if there had been any dissension at all and lack of cooperation, the surviving spouse, his lifestyle for the rest of his lifestyle would be compromised, because he would end up with 1/3 of the house that he should have had 100% of. So just because she hadn't, and of course, a lot of people, they don't have kids, they think, oh, well, it's less important for me to have a will because I don't have kids. No, you really need at least a will. So even if you don't think you have enough assets to justify having a living trust, for sure, do at least a will and a power of attorney and a healthcare directive.
And to protect your spouse, your surviving spouse, right? I had a similar case where the decedent had a child out of wedlock, but he acknowledged the child and, provided for the child financially, though less than. It was kind of like an estranged child and very difficult relationship. And the child grew up probably feeling abandoned and a lot of pain, as you can only imagine. And then when he passed, he had no provisions. And so I think the law in California is his new spouse got half, and the other half, in this case only one child, got the other half. And so now the spouse who's living in this house, can you imagine finding out your husband had an affair with some other person and has a child, and I think the mother of the child passed. But this love child now is now the half of your house, and oh, by the way, she wants to get paid, so she's forced to move out of the house. And so now she's faced with all the financial burden of having to move, she has no plan. She's not going to live on the half of the money, and knowing that the person getting the half is this love child who she rightfully had to stand for. And the emotion, I've never had an escrow where there was just more that I had to endure. Now, I'm a big boy, and people can call me names, and that's part of the job sometimes because I was referred by a good attorney, but man, the pain, and I just think to myself, that guy, there's no way he would want to cause pain to both his wife and this child to any human being, you wouldn't want to do that. So why not just, like you said, get the will, the power of attorney, and the advanced directives, at least as a minimum. No excuse not to do that. So let's kind of getting towards the end here, but I do want to kind of give some sense of what it takes. So somebody who's married, has a couple kids, a fairly uncomplicated life. I don't know what the average estate plan looks like. Let's just say kind of average middle America, Northern California family needs one. How much work is it? They got to call you up, make an appointment, obviously. There's some paperwork involved. There's some paperwork afterwards. What do you think is really is involved in going from I have nothing to getting a proper plan done that's going to cover, let's say, just the basics?
Right. So, if there's a lot of variables, but assuming just that it's a family where they have at least a piece of real estate. They own either a principal residence or another property. That's usually where it tips over. You say, the will, power of attorney, or healthcare directive, which is the sort of the most basic plan, may suit somebody very well if they have quite modest assets, and that the amount of time involved and the fees are substantially less than when you talk about having a trust. But if you have basically the purpose of a trust is can be manyfold. One is probate avoidance. Another is control. So if any assets are not going to go outright to an individual or loved one or whomever, and instead need to be controlled, say, certain percentages go at certain ages to the child or the immature, the less mature adult, then it's tough to do that with just a simple will and as opposed to a trust. So control and probate avoidance, and there's also creditor protection and some marital protection for the beneficiaries that can be built into a trust that just are not going to be present when you do a will and everything just goes outright. So there are a lot of reasons to do a full plan, including a living trust, but it really does depend on the circumstances. And, fees are going to be different among different states and different among different, attorneys. But if somebody's shopping to do a living trust, obviously, you get the old term, you get what you pay for. You want an experienced attorney, even if you need to pay, even if you need to, invest a little bit more to do that. And you want to make sure that there's apples to apples. For example, does the attorney prepare the trust transfer deed and give, and record it? Does the attorney give you instructions and supporting documents that you need? Is the attorney sophisticated so they can help you protect your children with some of the more refined kinds of provisions that provide marital and creditor protection for the beneficiaries? So there's super simple, straightforward, and there's more sophisticated and more robust plans that may cost a bit more, but in terms of fees, but that are going to give you a lot more bang for your buck.
And I'll just say, as a real estate broker, I often use services like preparing simple deeds, meaning a non-attorney paralegal online service that does that expensively and records deeds, and online notary. And still, for a trust, I would recommend have the attorney do it. You want the same person responsible for the whole package, because what you don't want is one person, one typo in one form, you're going to go to court. And you give somebody the chance to litigate. And the whole key, I think, of the trust and the plan is just close as many doors you can, take as many precautions as you can. And so I think this is a place where just a small amount of prevention is worth it, paying a little extra to get a professional to handle these things. And I think it's important that the attorney be willing to see the job through to the customers and as much as possible. So I appreciate your perspective on that. Robert, obviously I have your contact information. You have a website, Silverman & Jeffrey. PC is your firm. SilvermanJaffe.com is the website. You have all the information there, phone number, and I think you have a phone number people can call in and set up an appointment with your staff and go from a quick inquiry to an appointment with you? Is that kind of how it works for you as far as intake?
It can work that way. We also have a website contact form where somebody can, they don't even have to do an email. They can just hit the contact form and submit it, and we get an email. We also do send out, it doesn't cost anything. We send out an monthly email newsletter with a topical article that I write each month. Been doing that for well over 20 years. And so if anybody was interested in getting that free monthly newsletter, just shoot an email off or a website contact form. I have some other brochures that pros and cons of different types of manners in which you can hold title to real estate, and an estate planning primer. So there's some reference material that I'd be happy to provide people. Just shoot me an email, no obligation, no cost or anything. We just like to provide resources and education to people.
That's R. Silverman at silvermanjeffrey.com. Robert Silverman, thank you so much for your time today. I really appreciate you educating our platform and helping us all get a little smarter and hopefully inspire us to prepare a little bit to avoid those kinds of problems.
Great. Thank you very much for having me, Bill.
Very good. And I'm Bill Gross. This is Estate Planning Weekly. We get together every week. We most commonly interview estate planning attorneys, professionals that can help us in our job be more effective, whether you're a real estate broker or you're in the financial business, an attorney looking to get better resources, maybe out of your area as well. We do this every week. You can see us on YouTube at Bill Gross Probate is my YouTube channel. We continue the conversation if you want to on Facebook. We have a Facebook group called the Estate Planning Podcast. I'd love to have you there if you have questions or referrals for out-of-state resources, attorneys, realtors, and such. I'm at Bill Gross Probate on social media. Thank you, and as always, make today your best day ever. Thanks so much.